Professor George Hay. Hello, and thanks for talking to the Centre for International Finance and Regulation.
Pleasure to be here.
You've had a chance to review Professor Harper's draft report. What are the key issues from your perspective?
Well, it's a very long, comprehensive report dealing with a great many issues. I was asked to focus primarily on the competition law reform issues, a little bit on the governance issues, but it's the competition law issues that I'm most interested in.
Okay. Other than for horizontal agreements, should there be per se conduct prohibition?
As a general matter, the per se rule should be limited to conduct which is almost certainly likely to be anti-competitive. The view of most economists, I think, is that vertical restraints may be anti-competitive, but one can hardly say they're almost always likely to be anti-competitive. Indeed, they're probably more likely to be pro-competitive. So as a general matter, the per se rule has very little role to play with respect to things other than horizontal agreements. Having said that, the attitude towards resale price maintenance is long-standing in Australia. Same attitude exists elsewhere in the world. It changed only recently in America. I don't expect that to change here, and I don't think the other good things in the report should be jeopardized by having the report try to take on that issue. My prediction or my hope would be the per se rule would be eliminated for all vertical conduct other than resale price maintenance.
Okay, great. We'll come on to Section 46 in a moment, but what can Australia learn from Section 2 of the Sherman Act?
What they can learn, whether or not they decide to emulate it, is that Section 1 and Section 2 of the Sherman Act are quite different from the way Australian law is structured. Section 1 is a single sentence. Agreements in restraint of trade are unlawful. Section 2 is a single sentence. Monopolization or attempted monopolization is unlawful. The statute doesn't define those terms. It doesn't give examples of those terms. And so our courts are left to function as common law courts to work out over time what those terms mean in a factual context that helps them to understand them. So it's an evolutionary process, and that has the benefit that allows the courts to respond to the factual context, to learn from the factual context. Probably more importantly, it allows the courts to evolve over time in response to changes in economic thinking. The problem with a statute which defines everything is that I think it makes it much more difficult for courts to respond.
Yes. So moving on from that simplicity that we see in the Sherman Act, is there a problem with the current purpose test that Australia has in Section 46? And if there is, will the proposed revision in the draft report provide the answer, or is there a risk of Birdsville Mark II?
That sounds really like three different questions. There's a real problem with purpose in the test because it's possible for a firm to be convicted simply for having a bad intent. Now, there are other things it has to have a substantial degree of market power, but it's being convicted not for its actions, but for the intent behind the actions, independent of whether the actions have any consequence. I think from an American perspective, that makes no sense. It's not that purpose is irrelevant. Purpose is extremely relevant in America as evidence, for example, of likely effect. So if we had a statute which said the likely effect of substantial lessening of competition, the courts would be quite appropriately looking into evidence of intent to understand whether the conduct is likely to have an effect. But there's no way that a firm would be convicted simply because of its purpose.
Right, okay. And so moving on from Section 46, on cartels, the draft report calls for simplification. What would you advise in terms of simplifying the cartel conduct provisions?
Well, again, I think Australians can learn from Americans whether they decide to emulate it. The same statute I referred to, Section 1 of the Sherman Act, prohibits agreements in restraint of trade. Exactly the same statute can be applied either civilly or criminally. We have no separate statute. There's a difference in the burden of proof, but otherwise there's no separate statute. It's left to the prosecutor to decide whether to proceed criminally. Australia probably is not prepared to go down that path. When criminalization was introduced, there was a need felt to have a lot of explanation of when that power would be used. But my impression is that people think it's overly complicated, and some simplification would be good, even if it doesn't revert all the way to the American model of exactly the same statute, whether it's criminal or civil.
Okay. There's a proposal to separate the utility access regulatory functions, the AER, telecommunications, water, ports, etc., from the ACCC's competition law functions. In general terms, do you see this proposed separation as being beneficial or otherwise?
To me, it's largely a managerial rather than an economic issue. We, of course, don't have that issue in the United States. We don't have anything analogous to your access regulation. I think I've heard the argument made that there's an expertise in deciding when access should be granted and then the terms of the access, which really doesn't fit that naturally with the kind of expertise the ACCC has. And perhaps a separate agency which focused on that would be more efficient. I don't really have any strong feelings one way or the other, but I don't see any problem in separation. I don't see that it will undermine the ACCC's ongoing enforcement efforts with respect to competition law.
Okay. And following the governance theme, is it important to have independent oversight of the competition regulator?
Well, there is oversight now, I think. It partly depends on what oversight does, and I think I can imagine two kinds of oversight. The first is where you're overseeing decisions, particularly prosecutorial decisions. I think that's very dangerous. It seems to me, like the Department of Justice, where I worked for many years, the ACCC has a number of dedicated, quite bright lawyers and economists who get involved in a project and they try to see it to the right conclusion. To have that decision then overturned by some person that's not in the same building, not in the same room, not that they see on a day-to-day basis, I think can be terribly demoralizing. Mm-hmm. When I was in the Department of Justice, we had the great luxury that we made prosecutorial decisions. We would occasionally inform the Attorney General, but we were never overruled. And what it meant was that it made people work harder and with more conviction and more carefully, because we knew that we were being treated as professionals. So if the oversight is to oversee decisions and second-guess prosecutorial decisions, I think that's a mistake. I think that's what the Commission does. The Commission oversees the work of the staff. I can imagine oversight as a managerial tool. Is the Commission managing its budget efficiently? Are there too many layers? Are there processes which should be changed? And there's no particular reason why someone like an Alan Fels or a Rod Sims would necessarily have expertise in management. I mean, they're there for their expertise in competition law and economics. And so it seems to be perfectly appropriate to think about some other board which looks at the processes rather than the outcomes or rather than the merits of individual decisions, just to decide whether, from a managerial perspective, the Commission is being run efficiently.
Okay, great. Do you think a public interest test is the best way to ensure that governments cease restricting competition?
I think that there are many versions of the test. I mean, obviously, the goal is to have a fair playing field and have government out of the picture as much as possible. Yep. I think there are many different tests that can be used to do that. I think it's a concept that we don't want the power of the government to distort competitive processes.
Okay. You've been an expert in a number of cases in Australia. What's your view on the way that economic evidence is treated by Australian courts?
I think there are two issues. One is it's treated very differently by Australian courts generally than it is in America. In America, economists are welcome, encouraged to try to find evidence, to gather evidence, to look for facts, to bring to the attention of the court evidence which the economist regards as relevant, and then perform analysis on that evidence. As a general matter, Australian courts like to preserve the fact-finding mission to the judge, and they want the economist to provide analysis based on the facts that the economist either is given or may assume. And That's fine, and there are a whole lot of reasons which aren't going to be changed where that might be appropriate. What has troubled me a bit more is that within the Australian court system, in the 5 or 6 federal courts I've been involved in, the practice is not uniform. Mm-hmm. Some courts allow economists a lot more discretion to get involved, to get his or her hands dirty in the evidence. Other courts seem to want the economist to do nothing more than to read a paragraph from an introductory textbook. And sadly, the report didn't really touch on that at all. Mm-hmm. And maybe that's going to happen in some other report aimed at different purposes. But when and if it happens, I'd like to see somebody examine that disparity that occurs within the Australian court system.
Okay. Well, George Hay, thanks very much for talking to us. It's been very interesting.
You're entirely welcome.